Hello and welcome to the agenda. I am Ajay Kaul. Today we will talk about the slow pace of justice in Rubiya Sayeed abduction case in Jammu and Kashmir. Rubiya Sayeed, daughter of the then Union Home Minister Mufti Mohammad Sayeed, was kidnapped by terrorists in Kashmir on 8th December 1989. She was freed after 5 hardcore terrorists were released by the government. Now, after more than 31 years of the incident, charges have been framed in the case against JKLF chief Yasin Malik and 9 other terrorists. What does it say about the country's justice system? We will discuss this in the agenda today. We have with us Mr. Kulbir Krishan and Mr. Kuldeep Khoda, two top former officers who have served in Jammu and Kashmir and dealt with the terrorism situation there. But before we begin our conversation, let's have a look at this small report.
More than 31 years after the abduction of Rubiya Sayeed, daughter of the Union Home Minister late Mufti Mohammad Sayeed, Special TADA Court in Jammu has framed charges against Jammu Kashmir Liberation Front chief Yasin Malik and 9 other terrorists. The TADA judge observed that he was of the considered view that sufficient ground exists for drawing prima facie presumption that Yasin Malik and 9 others committed the offences of entering into criminal conspiracy, kidnapping Rubiya with an intention to murder and keeping her in wrongful confinement under provisions of Ranbir Penal Code. Apart from Terrorists and Disruptive Activities, TADA Act and Indian Arms Act, the 10 accused are among 24 accused named by CBI in its charge sheet filed before the TADA court. According to the CBI charge sheet, the accused entered into a criminal conspiracy in the first week of December 1989 to kidnap Rubiya. When undergoing resident internship training in Lal Ded Hospital at Srinagar for ensuring the release of 5 associates lodged in different jails. Rubiya was kidnapped just weeks after her father became the Union Home Minister in the VP Singh cabinet. He was freed after release of 5 hardcore terrorists, including top JKLF commander Hamid Sheikh. The incident gave a huge boost to terrorism in Kashmir, since the release of 5 terrorists in exchange of Rubiya Sayeed was seen as a victory for terrorists. In fact, this incident was followed by a series of other abductions of high-profile personalities, and many terrorists were released. So this case stands out, and rather than the culprit being punished, they have enjoyed freedom all these decades, just because the justice system was so slow. Bureau Report.
Now let's welcome our special guests, Mr. Kulbir Krishan and Mr. Kuldeep Khoda. Welcome to the program, sirs. So let me begin by asking Mr. Kulbir Krishan, like it's now more than 31 years since Rubiya Sayeed was kidnapped in Kashmir and 5 hardcore terrorists were released. And it's now 31 years later that charges have been framed. What does it tell you about this judicial system or justice system?
Many times held that speedy trial is very much a part of Article 20. And in fact, sometimes cases have been thrown out because of the inordinate delay in prosecution. But in this particular case, I feel that there are a lot of extenuating circumstances, and the kind of atmosphere which prevailed in Jammu and Kashmir during the 90s, and also the various twists and turns which have taken, have led to this delay. And this delay is very unfortunate, and the quicker the wheels of justice move, the better it is for all.
Mr. Kuldeep Khoda, as you heard Mr. Krishnan about the situation prevailing in Jammu and Kashmir. So why this delay? Why is it justified so 31 years for just framing of charges?
Uh, the criminal justice system in our country has been awaiting reforms right from independence, who have inherited, which was brought by the Britishers, wherein emphasis was laid on various some of the scrutiny at the international level, and when India was undergoing the freedom struggle, there were lots of safeguards tried to be put into place by the British government to project a face of good judicial system wherein the accused is convicted only after very, very strong evidence. But that was a facade to show to the world where actually the justice was dispensed very speedily. You can remember the cases of various martyrs during freedom struggle. But we in India, after Britishers left, we inherited and continued the system mainly with the objective of ensuring that not a single person is convicted against whom there is no sufficient evidence, yet others who against whom, even if the court feels that a person is involved, he should, but there is not sufficient evidence, let him get free. The intention of criminal justice system is not like that. The criminal justice system is primarily meant to ensure that the accused against whom charges are proved or established, they get convicted. What has happened in the process of trying to cater to various galleries is that the people, the criminals who are involved in various crimes, leave aside the terrorist crime, which is much more harsher and calls for even speedy trial. But even in ordinary cases, the conviction rate is very low. It is, yes, the judicial system has in fact that the judgments are written. Some lacuna is found somewhere, and taking help of that lacuna, the entire process appears to have been designed to see what excuse or what all can be projected in the judgment, which can lead to the acquittal of the accused. Now, with having this sort of mental frame of mind, it is very difficult to get cases convicted in India. Even the very specialized investigation agencies like CBI and NIA don't have high rates of conviction, leave alone the police investigations. Now, in the case of Yasin Malik, if you remember, his main case was against the killing of 4 IA in Indian Air Force personnel, including one of one foreign leader on 25th of January 1990.
Yeah, I was thinking of coming to that later. Yeah. But
and the charge sheet was presented against him in November 1990 after a detailed investigation by the CBI, wherein there were eyewitnesses also.
And he was himself. He has himself admitted on TV that he has killed 4 IF officers, personnel.
They leave aside. In our criminal justice system, a person cannot do evidence against himself. He cannot be. He admitted something. He cannot be cited as a witness against his own case, against himself. But apart from that, there were several eyewitnesses. The facts of the case were also there. The circumstances were there. Forensic evidence was there. And they, on very small pretext, the case was stayed. And it was only in April 2020 that the stay was vacated after series of measures taken by the government to ensure that the stay is lifted.
Right.
And now his trial is proceeding. And now he is lodged in Tihar jail in connection with the Hawala transactions also. But apart from that, if you look at our criminal justice system, in most of the terrorist crimes, the people have been acquitted. And this raises a very serious question about the role of judiciary in protecting the integrity of the country and the safety of its citizens also. So what is required is that A, the trial should be very speedy. B, that we don't have to look for technical reasons as is happening right now to see how an accused can be acquitted. Rather, we have to see at the primary factors which can be held against the accused on the basis of which he can be convicted.
Right.
And the evidence should be sufficient to convict a person. It does not have to be an ultimate evidence. It should be just sufficient to see that the judges are convinced that he is involved in the crime.
Right.
So, but I give a word of caution here. A word of caution is that the judiciary is independent and it should be independent in any democratic country, and the government or the political or the bureaucratic establishment should not intervene with it. And the judicial reform should come from within the judiciary. But we have found that despite concerns expressed by the highest court of the country, that is Supreme Court, to giving various directions to the lower courts to see that the presence of cases reduced drastically.
Right. So,
And people are the cases are decided quickly. Nothing much is happening. In fact, instead the cases are compiling and the number of cases under pendency is going up and up. Only it is not coming down.
yeah, I'll come to I'll come back to you on that. So, Mr. Kulbir Krishna, as you heard Mr. Khoda about that, I mean, accused cannot give evidence against himself, and there are other also evidences like if he, I mean, giving an interview is not treated as evidence in court, and there are other so many loopholes which are being exploited by terrorists and other criminals. Doesn't it send a very wrong message?
On legal principle that let 100 innocent, let 100 guilty people go free, but let not one innocent people suffer.
Right.
That may be very good in theory, but the fact is that if hundreds of thousands of guilty people get away scot-free, then the whole criminal system comes into contempt.
Right.
And which is why extrajudicial measures, as we have seen in UP and Andhra Pradesh and others, become sanctioned by public at large. Therefore, the question is that the judicial system has to work, and it has to work in a speedy way. Here, in this particular case, it's true you cannot self-implicate yourself, but a confessional statement is a confessional statement. It can be taken on record. Similarly, there are many other instances where, in this particular case, whether it is the kidnapping of Rubiya Sayeed or the killing of squadron leader Ahuja and other Air Force officers, the evidence is overwhelming. But the fact is that the evidence has not come before any court so far. And that is the tragedy of the whole situation, that 31 years have gone and only now charges are being framed. And then when the cases will be heard, it will take another 4-5 years, then you go to High Court, then you go to Supreme Court. So
it's a never ending. It's a never ending.
Getting serving justice is defeated.
Right.
And that cannot be allowed and should not be allowed.
So, as you talked earlier about accentuating reasons were prevailing in Kashmir at that time, but there is always a provision of maybe transferring a case outside J&K to allow maybe protection to eyewitnesses and others to ensure speedy justice.
No, now that's why it has been moved to Delhi now.
No, it's
and
very
Yasin
late.
Malik is in Tihar jail.
Yeah.
I cannot answer why it was not done 10 years ago.
I'm not saying, I'm not asking answers to you, but I mean there is a provision which could have been used earlier.
Yeah, it should have been used, particularly in this particular case, because the evidence is so overwhelming, and he is himself on record to say that yes, we did it.
Right.
And in fact, he was the one negotiating. So he said yes, Rubiya was us.
Right.
So where is the question of he not being involved?
Right. And I also remember after this incident, there was a big boost to terrorism in Kashmir. And also there was a series of kidnappings also for release of terrorists. Mr. Kulbir Krishnan, I think you were there at that time. Maybe you can throw some more light.
I was there, and it was very true. There was a big boost. And in fact, the situation almost went out of control. and it was required very deft handling and very strong handling to bring Kashmir back on the rails. And when Dr. Farooq Abdullah, who was the Chief Minister, had himself said at that time that it is the centre which is negotiating and I am kept in the dark and I don't know what will happen, but I will have to face the repercussions. And it is only when, even after President rule came, it took many years for things to come back, which is why elections were held only, as you know, in
96.
97.
96. 96.
96.
Yeah, I covered those elections, so I remember. This incident, Rubiya Sayeed, when 5 terrorists were released, it gave a boost to terrorists, and after that they kidnapped so many others. There were so many other kidnappings, high-profile kidnappings, like the kidnapping of Kashmir University Vice Chancellor Mushirul Hassan also, and IOC Director Duraiswamy, HMT official H.L. Khera. There were a series of kidnappings for release of terrorists. So, in fact, instead of giving a message there and then, it was let loose. The situation was let loose at that time. Your comment on that?
Absolutely. This became a handle with the terrorists in the early 90s to kidnap people and get the terrorists released. But fortunately, later on, the better prevailed on the establishment. And this process of releasing terrorists in exchange for kidnapped persons was stopped. It started with the boost came when the daughter of former Home Minister Rubiya Sayeed was released in exchange, and that was taken as a one boost and victory of the terrorists. And this just added the required spark to the initial phase of terrorism, and it started blooming in Valley. And I don't know what were the compulsions of the government in trying to ensure that the terrorists are targeted rather than being released. And later on, of course, it was stopped. But the point still remains that the government has been soft-pedaling in terrorism over years. Even Yasin Malik, when the stay was obtained on his trial, which lasted for more than 20 years it lasted, and the efforts were not made by the government to get it vacated. Leave alone that, he was even invited for peace talks with the then Prime Minister,
right,
Dr. Manmohan Singh, where he attended a roundtable conference with him. Then this is the type of projection given the terrorist who is involved in killing of the defense personnel of our country, wherein not only the trial is allowed to remain suspended because of the inaction of the government, he is even invited for talks with the highest authority of the country. And if you deal with terrorism with this sort of mind, we can only expect results which can only lead to increase in terrorist levels, and the events which continue with the terror activity are an example for itself. Even we can't forget the prima incident where 37 persons were martyred in the terrorist violence.
Right.
This is because of the vexing and waning of our response to terrorism. No coherent policy in dealing with the terrorism, no clear-cut policy in dealing with Pakistan, where from the entire terrorism is emanating. Locally also, sometimes taking terrorists as sort of ambassadors who can be talked to in restoring peace in Kashmir. This is not the way to deal with terrorism.
Right. So, in fact, when we talk about messaging, he pointed out that Yasin Malik, who was a known criminal and no terrorist, he was invited to a round table with the Prime Minister. So, what kind of messaging? And after he has admitted openly that he killed 4 IAF officers, after that also he was invited to the round table with the Prime Minister, no less than the Prime Minister. What is the messaging?
Obviously, the messaging is, as expecting, inviting a terrorist who is involved in a serious terrorist crime, which involves killing of 4 senior officers of the Indian Air Force. if he is invited at the highest executive level of the country for talks, you can only presume on safety also that the terrorists are going to get abused. On one hand, they will kill our defense personnel, they will kill innocent people, they will kill the political establishment, they will attack the security forces. On the other hand, we will try to approach them with peace overtures. This is no way of handling terrorism. We have to have a very clear-cut policy in dealing with terrorism. We have to have a very clear-cut understanding and implementation of that understanding on ground in dealing with Pakistan, so that effective results are achieved. If we believe any in our approach, if we are not very sure about how to deal with the Kashmir issue, then the results can only be disastrous.
Right.
We cannot reach anywhere. That's why the terrorism is continuing for more than 30 years, and we are still not knowing how to go about it. The terrorism is continuing. The terrorists are infiltrating. The incidents are happening. People are getting killed. Terrorists are getting killed. Innocent people are getting killed. Pakistan is continuing with this terrorism.
Right.
We are really not dealing with the situation to finish off the terrorism. We don't have any clear-cut policy in ensuring that terrorism is finished once for all.
Right. So, Mr. Kuldeep Krishan, I will ask you, Mr. Kuldeep Khoda raised a very important issue about when Yasin Malik, everybody knew, he had himself admitted of killing 4 IF officers, and even after that he was invited to the round table with no less than the Prime Minister of India. So what is the message?
So that's what I was saying, that there were a lot of flip-flops at that time. At the time of Rubiya Sayeed, 5 dreaded terrorists were released.
Right.
Later, when Mr. Jagmohan was the governor and there was governor's rule, he said, "I will not negotiate with anybody," which to my mind was the correct policy.
But
and
that
then,
but that
Mr.
also,
Lassa Kaul, of station director of
but that also, but sir,
Doordarshan,
yeah, please.
was killed, because he said, "I will not negotiate under the barrel of a gun." What is required is we should have a clear policy like the US has. The US clearly says we will not negotiate with terrorists.
Right.
Not only we should have a policy, we should publicize it and say under all circumstances we will not. We cannot go case by case. Doraiswami's case something, Rubiya's case something. You cannot see the man. The policy has to be the same. And fortunately, we have learned from our mistakes, and now there's a clear policy, and now this kind of kidnappings, etc., don't take place.
Right. But as I mentioned earlier, there were a series of kidnappings after that, and we released terrorists. Like in Doraiswami case or Mushirul Hasan case, we released so many terrorists. I think 7 terrorists were released at that time.
Not only that, if you recall, when some terrorists were holed up in Hazratbal Shrine,
right,
they were also given free passage to Pakistan.
Right.
Why should we do that? And we have to think about it. We should be very clear. We have a strong NSA now. We have a clear policy now, and the policy should be well enunciated so that there is no ambiguity. Aap loge, you will get the crime, you will be punished for it. And you cannot get away with murder or kidnapping or things like that.
Right. That has to be demonstrated on the ground, isn't it, sir?
Correct.
And
to some extent it's being done now. To a great extent it's being done now.
So
unlike in the past where there were a lot of flip-flops.
Right, we hope so. But we also have a case of Bita Karate, who is also admitted to killing more than 40, he says, Kashmiri Pandits. And he has not got the punishment actually appropriate what he should have been. He should have been hanged long back. So what do you say, Mr. Krishan?
He should have been hanged. In fact, but the fact is that you have to bring the evidence. And unfortunately, at that point of time, evidence was very difficult to come by. This is why he was detained under PSA and other laws, and he served that sentence and came out free.
Right.
But there is no time limit for murder. He has done so many murders, not only of Kashmiri Pandits, also of
Muslims also.
Intelligence officers.
Yeah.
And so he is a person of interest to the security agencies, and he must be brought to book.
And he was a serial murderer, in fact, not isn't
Yes,
it?
that's what I'm saying. That
So-
he is definitely, since there is no time limit, and since all cases have not been investigated, if we can build up the case, get the evidence, then he should be brought for trial. The only problem is that our system is very, very slow, which you have already pointed out.
Right. So was it only the system slow, or there was kind of protection being provided by people in the system, maybe in political level, administrative
That's
level?
what I'm saying. There was no clarity. At sometimes you wanted to talk, at sometimes you wanted to prosecute, and with each change of government there was a different thinking and so on. But these are not, these are actually, a murder case is a murder case.
Right.
It doesn't matter which government is in power. It is the judiciary which has to decide. But it is the police which have to gather the evidence and put it forth. Whether it's the police or whether it is the CBI, it is the investigating agency which has to collect the evidence and put it before the court, and the court will then decide whether the evidence is sufficient to convict or not convict. And
Right.
once convicted, what is the quantum of punishment? That's the honorable court will decide.
Right. So, Mr. Khoda, I'll ask you, since you have been the police chief there, so what is hampering this process of investigating and gathering evidence? We know it's not Rubiya's case, Rubiya Sayeed case only, or Beta Karate or Yasin Malik. There are thousands of cases still waiting for justice over last 40, 30 years. What is its topic? Why so? What is the problem?
No, you have raised a very important and pertinent question. As far as happening investigation is concerned, in terrorist crimes, mainly you don't find either there are no eyewitnesses, or if there are eyewitnesses, they are very hesitant to record their evidence or to come to the court, suppose before the court against the king because of the fear of death. Beyond that, the forensic evidence which is collected, that is done. But even with these sorts of problems, it was not very, very difficult to ensure that the terrorists are prosecuted successfully and punished also. They are given an exemplary punishment so that other terrorists could get a lesson and think twice before entering the path of terrorism. But unfortunately, in this country, we have a huge brigade of people who come in support of these sorts of people in the name of democracy, liberalism, human rights champions. Even a person like Abdul Guru, who was hanged, given a death sentence and hanged, the questions are still being raised. When the enemies are within the country, it doesn't require a real enemy from outside to come and raise the voice for the enemies of the country, because they have got helpers and supporters within the country. There are lots of people petitioning before the Supreme Court. Even the Ajmal Kasab case, the hearing was held in the middle of night. The system and the type of people who are coming forward to help these enemies of the country, they need to also be dealt with severely. And such person who, in the name of liberalism or human rights, so-called human rights champions, who come and directly or indirectly help the terrorists, they should also be booked.
Right.
And take charge shooting. And the Evidence Act and our penal code should be appropriately amended to introduce this person so that the administration of criminal justice is done without any hindrance, without any obstacle, and these sorts of people never come forward to help the terrorists who are acting against the people of the country and as instance of the enemy.
Right.
So we require a major overhaul of our criminal justice system, not only the functioning of the judges in the High Court and the Supreme Court and lower courts, but also revision in our law books, particularly the criminal, those dealing with the crime, like Penal Code and the Evidence Act and Procedure Code.
Yeah, but we hope that now justice system will be overhauled. But as Mr. Kulbir Krishnan mentioned, that now the government is very strong and no compromising. We have a very strong NSA, and we hope that now justice will be done. All these cases which have been waiting for decades. But my time is up. Thank you both of you for participating in this debate today.
Thank you.
Thank you.
This is all in the agenda today. Thanks for watching. I'll be back with another important topic tomorrow. Till then, goodbye.